next speaker will be Attorney Joe Elford, who works for Americans for Safe Access and represented, actually argued before the state Supreme Court the case Ross versus Raging Wire, which you have heard so much about. I must say he did a very able presentation. I just wish the judges had listened a little bit better.
Thanks, Dale, and thanks for not introducing me as Joe Elford, the lawyer who lost the Ross versus Raging Wire case, which is how they like to refer to me at work. I'll talk a little bit about what the law is relating to all of this. I'll also, of course, talk about the Ross versus Raging Wire case and where we're going to go from here. And there are several just sharp divides that actually don't seem to make a whole lot of sense, but that's the way the law works frequently. One major divide is pre-employment drug testing versus drug testing after you're already on the job. The courts tolerate pre-employment drug testing, but they actually don't tolerate testing on the job, except under the separate, and this is the other big divide, safety-sensitive positions versus non-safety sensitive positions. Under federal law, if you're in a safety-sensitive position, a truck driver, crane operator, stuff like that, then they will test you consistently while you're on the job. But if you hold a non-safety sensitive position, they won't. What people aren't really familiar with is a case that we all should be familiar with, and it's a case called Seymour versus Poole. And it's a case that actually comes out of the California Court of Appeal in 1990. And believe it or not, what this case says is that you can state a cause of action against an employer for violating your right to privacy if your employer requires you to take a drug test after you've already held the position and there's no cause for that drug test. In other words, if you're not involved in an accident, the employer is just curious and asks you to take a drug test, you can actually sue the employer. And California is the only state, out of all 50 states, California is the only state that has this right of privacy that forbids drug testing after you're already on the job without cause, unless you're in a safety-sensitive position. But that was in 1990. And since then, we've regressed. The law has taken several steps backwards, and hopefully that will soon improve. The next big case is a case that comes from 1997, and it's the case in the field, and it's called Loder versus City of Glendale. And what Loder involves, it was a public employee who they were testing the employee. The employee had been working there for several years. It was actually a group of plaintiffs. So you had one group of plaintiffs who were just new to the job, and they wanted to test them. And the other group of plaintiffs were folks who'd been on the job for several years, and they got promotions. They wanted to test them in order for them to secure their promotion. And in a very sharply divided 4-3 decision out of the California Supreme Court, over just the question, can the court drug test someone at all? That we're talking about for heroin, cocaine, meth, you name it, just on the question of whether they can drug test you at all. At that time, the court was split 4-3. Saying, yes, they can drug test you for at least in terms of pre-employment drug testing. And pre-employment is broader than you might think. It's anywhere in the first 60 days when you get a job, they can give you a drug test, and that's considered pre-employment. And their reasoning was because of, quote, the well-known abuses, unquote, associated with drug use. And then they listed some of them. Increased absenteeism, increased tardiness, and accidents. They don't say any statistics to support this. And in the dissent, at the time it was Justice Moss writing a very strong dissent, pointed out that they can't just say well-known abuses associated with drugs. They're a court, they actually should have to rely on some kind of actual evidence. Of course, the court didn't do that. But they did say that you can't drug test someone when you give them a promotion. I mean, you would think with the well-known abuses that if they're so well known that they would be able to drug test you at that point as well. It's a different job, it's at some level. But there the court felt that the abuses weren't so well known to justify the intrusion into your privacy. And the rationale is you're a known commodity. If they're giving you a promotion, you've presumably been working there for several years. They can tell if you're going to have increased absenteeism or if you have drug problems that will impair your ability to perform the job. It's a weird split. I mean, it's certainly a more welcome split than they can just drug test you anytime they want. But it's a weird split that really doesn't have a whole lot of justification, either law or logic. Which will bring us to the Gary Ross case, where it gets far, far worse. Gary Ross, I'm not going to tell this, you've heard the story presumably a couple times by now. Gary Ross was a former U.S. Air Force, or he's a current U.S. Air Force veteran. He hurt himself while serving in the Air Force. Severe back problems causing back spasms and spasms in the upper part of his legs. So his doctor recommended that he use marijuana primarily in the evenings so it would help him sleep, so it would help him be able to be a more productive worker. He then gets a job as a computer systems administrator with a company called Raging Wire, which despite its name isn't a very radical company at all. They gave him a drug test and then they fired him when he tested positive, knowing full well he was a medical marijuana patient and having a copy of the doctor's recommendation. So Gary Ross sued in court. And there were two causes of action, but the primary cause of action was under the Fair Employment and Housing Act. And it was simply a straightforward application of the Fair Employment and Housing Act. California's Fair Employment and Housing Act requires an employer to provide a reasonable accommodation to any disabled person. Gary Ross is disabled. The reasonable accommodation he requested was that they don't fire him for using the one substance that makes him a better worker on the job, and that in no way impairs with his ability to perform the job. So you'd think we might win the case. ASA got involved in the case after there was already a negative published decision that came out of the Court of Appeal. And in that decision, which was actually even more nasty than the ultimate decision, in that decision, the court, and in particular Judge Scotland, who wrote the decision, said, well, we know that the Fair Employment and Housing Act doesn't cover medical marijuana patients, and the Compassionate Use Act was never designed to cover medical marijuana patients because the Compassionate Use Act was designed only for people who were too sick to actually be able to hold jobs. And that was the reasoning in that case, which is what reading that got us involved. So I called up Gary Ross's attorney and offered to take the case if he would have me as co-counsel, and the case went on. Believe it or not, I actually thought we'd win the case. And other people did as well, because it's unusual for the California Supreme Court to grant a petition for review and not reverse the case that they're reviewing. And here you actually have the unusual result. What ended up happening at the oral argument, during the oral argument, was actually during questions to my opponent, it became very clear in my mind that we were going to lose the case. We ultimately did lose the case in a sharply divided 5-2 opinion. The one Democratic appointee on the bench, of course, was on our side, as well as one of the 6 Republican appointees, and wrote a very sharp dissent. The case has been criticized and actually was called in the California Loder magazine one of the 2 worst decisions of 2007. In any event, knowing that we were likely to lose the case, we approached Mark Leno even before the decision came out. And Mark Leno was willing and actually very enthusiastic about offering legislation that would reverse what we knew was going to be a bad decision. And so the very day that the California Supreme Court announced its decision in the Ross versus Raging Wire case, denying civil rights to medical marijuana patients, Mark Leno introduced legislation that would clean that up. In fact, it would have been far broader than even a victory in the Ross versus Raging Wire case. That legislation did pass, as you heard, through the Assembly and then through the Senate. Unfortunately, Arnie vetoed it. But the good news is, in the future, in the very near future, it is very likely that this bill will pass through the Assembly, the Senate, and actually then get signed by the governor at that point in time. And so I think civil rights for medical marijuana patients is on the horizon. And I'll conclude with this, is when I was talking about the Ross versus Raging Wire case, before the case was decided, in fact, before it was argued, I made comments about the fact that if medical marijuana patients can be fired simply for being medical marijuana patients, they have no civil rights at all. I was reminded that I had said this by a reporter the day that the Ross versus Raging Wire case was decided. I continue to believe that at this point in time, unfortunately, medical marijuana patients do not have the civil rights that they ought to be entitled to, but I believe that will change within the next couple of years. Thanks.